Mitchell wants to know what the standard of proof is in the criminal law. Well, in just a moment, I'll explain that. The standard of proof in criminal law is beyond a reasonable doubt.
Now here is one definition of that. It comes from the legal part of Merriam-Webster, and it says a doubt about a criminal defendant's guilt arises or remains upon fair consideration of the evidence or lack thereof. Well, that's a pretty poor definition. The fact of the matter is that no matter what set of words are used to define reasonable doubt, some ambiguity remains with respect to what reasonable doubt really is. Here it says, a reasonable doubt exists when a fact finder cannot say with moral certainty that a person is guilty or a particular fact exists. It must be more than an imaginary doubt, and it is often defined judicially as such doubt as would cause a reasonable person to hesitate before acting on a matter of importance. But that also may not necessarily be a good definition of the concept of reasonable doubt.
Now, that does not mean beyond all doubt. It means beyond a reasonable doubt.
Here is the way the courts in the Ninth Circuit, which is in California, the federal courts out there, here is how they defined reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced the defendant is guilty. It is not required that the government prove guilt beyond all possible doubt. A reasonable doubt is a doubt based upon reason and common sense and is not based purely on speculation. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If a careful and impartial consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find the defendant not guilty. On the other hand, if after a careful and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find the defendant guilty. Now you might be wondering who's to blame for all of this doubt and ambiguity with respect to a reasonable doubt. Well, this is from a law review article that says it's the lawyers and the judges that are at fault, and they're right about that in this particular case. At one time, judges told the jury about the law in frank, natural language. The judge just got up and told them what he believed the law should be and what the law was with respect to reasonable doubt. And that was used to guide juries in making these determinations. The good judges from the 18 and early 1900s were excellent at this, because they understood the juries in their communities and they knew what words would work, how to tell them what it was that the jury needed to know. But over time, the process became a little different than that, in that what happened was lawyers would submit instructions that they wanted the judge to read. And indeed, that's how it works now. The defendant's attorney gets to submit instructions and the prosecutor gets to submit instructions, and the judge has to choose which and when to give those instructions. And that can make it somewhat of a difficult process at the appellate level, trying to sort out whether instructions could have been given or should have been given differently. The bottom line is the only way to have instructions immune from an appellate challenge is to have them defined by the appellate courts up front. And that is pretty much what the Ninth Circuit did with the earlier set of instructions that I read just a moment ago.
When is it reasonable to doubt the state's case? Well, often when there are alternative possible explanations for what happened. A good example of this would be the Chauvin case, which is going on right now as I'm filming this. And the issue there is whether or not kneeling on someone's neck caused or basically killed this particular individual when that individual had a lethal dose of fentanyl in his system. Now, both sides have experts. Both sides' experts have differing opinions. that, in my opinion, creates reasonable doubt. But I'm not sitting on the jury. I haven't heard all of the evidence, and it's not my intent to ever criticize a jury.
Judge Ruth Bader Ginsburg, God rest her soul, was at the forefront of trying to determine what reasonable doubt was. And she liked this instruction. The government has the burden of proving the defendant's guilt beyond a reasonable doubt. Some of you may have served as jurors in civil cases when you were told that it is only necessary to prove that a fact is more likely than not true. In criminal cases, the government's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are few things in this world that we all know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. Judge Ginsburg thought that this was right. She said the instruction plainly informs the jurors that this prosecution must prove its case by more than a mere preponderance of evidence, yet not necessarily to an absolute certainty. The firmly convinced standard for conviction, repeated for emphasis, is further enhanced by the juxtaposed prescription that the jury must acquit if there is a real possibility that the defendant is innocent. So, as you can see, not only state courts but federal courts have wrestled with this idea of what is proof beyond a reasonable doubt. And it is not always easy to define, but I believe it's very much like the judge talked about pornography. I know it when I see it.
My point is, reasonable doubt is something that makes you pause. It makes you say, well, there is a possibility that he did not do this. And if that reaches that hurdle, then I think you have to vote to acquit. So that's the standard of proof beyond a reasonable doubt. Like I said, it doesn't mean beyond all doubt. It just means beyond a reasonable doubt. And it's a jury question. It's something that a jury has to decide as to whether or not it's reasonable to doubt the state's case. So if you found this interesting or helpful or informative, I'd appreciate it if you would slap that like button and perhaps subscribe to the channel. If you hit the notification bell, you'll be notified every time we release a video on this channel. Thanks for watching. Have a great day.